Karen Reed just filed a civil lawsuit against the Massachusetts State Police and the Canton Police Department, and it is explosive. Welcome to the Margaret McLean Show. I'm your courtroom translator. I'm not in my studio this weekend, but I felt it was really necessary to make a video because I used to be a civil trial attorney and I worked on cases like this. I tried cases like this, so I'm going to really take you behind the scenes and dig in. I'm going to explain the law. The complaint contains text messages attributed to former State Trooper Michael Proctor and former Canton Sgt. Goode that include racial slurs, antisemitic remarks, misogynist comments, praise for Adolf Hitler, discussions about planting cocaine on people, and statements suggesting violence against others. I read through those text messages when the case first came out, and I had trouble sleeping that night because I've never seen anything so vile and disgusting and full of hatred. It was really disturbing. So I have to separate the outrageousness of those texts from the actual legal liability in this case. The lawsuit argues that these were not isolated jokes, private opinions, or lapses in judgment. According to Reed's attorneys, the messages revealed deeply rooted prejudices that made both men unfit for positions of public trust and ultimately influenced the investigation into John O'Keefe's death. The complaint describes Proctor and Goode as inveterate bigots whose longtime friendship was built around shared hostility toward women, minorities, Jewish people, gay people, and others. It alleges that the Massachusetts State Police and Canton Police Department either knew or should have known about these attitudes and failed to act. Legally, this case is about negligent hiring, retention, and supervision. It's about institutional accountability. What were the internal policies? How extensive were background checks and training? Was there oversight? And whether bias within an investigator can undermine the integrity of an entire criminal investigation. The issue is not whether the texts are offensive. Of course they are. They're vile. They're the worst I've ever seen. The issue is whether the Massachusetts State Police and Canton Police Department knew or should have known that officers entrusted with enormous investigative discretion held deeply rooted biases that could affect the course of a criminal investigation. In my opinion, one of the most fascinating allegations involves Michael Proctor's hiring. The lawsuit references a 2017 text in which Proctor wrote, quote, "No idea how I passed the background," unquote. The complaint also points to a 2013 message where Proctor warned friends that a state police investigator would be contacting them during his background investigation. I find that very interesting. So the obvious question for plaintiffs' lawyers becomes, did the Massachusetts State Police exercise reasonable care when conducting Proctor's background check? The complaint further alleges that Proctor unsuccessfully sought employment with the Boston Police Department before joining the state police. If Boston identified concerns with Proctor, what happened to the state police? Did they just miss something? Did they ignore red flags? Did they exercise due diligence? Negligent supervision may be the strongest institutional claim. The lawsuit references thousands of communications spanning years. I'm talking thousands. Plaintiffs' attorneys will argue if these communications existed over such a long period of time, what systems were in place to identify misconduct? For example, what oversight existed? What were the warning signs? Were supervisors aware? Should supervisors have been aware? What were the reporting mechanisms that existed? What about disciplinary mechanisms and systems? What policies governed personal phones and electronic communications? That will come out in this lawsuit. What did they know and when did they know it? This is the central issue. Every negligent supervision case eventually comes down to the same questions. What did the employer know? What should the employer have known? When did they know it? And what did they do about it? Those questions will likely dominate discovery in this case. The discovery battle is likely going to be the most important phase of this lawsuit. Plaintiffs' lawyers will seek personnel files, internal affairs records, disciplinary histories, background investigation materials, promotion records, training records, department policies, of course, electronic communications policies, that's a big one, internal complaints, and prior allegations of bias. They will attempt to determine whether warning signs existed long before Karen Reed was investigated. Believe me, there's going to be quite a battle over the admissibility of these text messages. The court will ask, are they probative? Do they help prove a relevant fact? Or are they simply inflammatory and unfairly prejudicial? The defense will argue these offensive comments are disgusting, but they do not prove that Karen Reed was framed. The plaintiffs will argue the texts reveal the mindset of investigators exercising enormous discretion in a criminal investigation. And this is going to be a significant legal battle. You wait. One thing I learned as a former prosecutor is that members of law enforcement must make many decisions every day. They have to make judgment calls. For example, they have to decide which witnesses to believe, which to ignore, which leads to pursue, which evidence to collect, and the alternative theories that deserve investigation. The plaintiff's argument is that deeply rooted prejudice can influence those decisions, not necessarily through overt misconduct, but through discretionary choices that shape the entire direction of an investigation. The biggest challenge for the plaintiff, Karen Reed, will be proving causation. Her lawyers must connect the prejudicial attitudes of Michael Proctor and Sean Goode to actual decisions made in the criminal investigation against her. Was the criminal investigation into whether she struck her boyfriend, Boston police officer John O'Keefe, with her SUV tainted from the very beginning and throughout the entire thing? That's what they have to prove, causation. Overall, if Karen Reed can prove that these biases were known, ignored, or should have been discovered through ordinary supervision, this lawsuit could become a landmark case about institutional accountability. I do hope that these ex-members of law enforcement, Michael Proctor and Sean Goode, will suffer the consequences. And I also hope that this lawsuit serves as an example for institutions to better monitor their employees. Once again, thank you for watching the Margaret McLean Show. Be sure to subscribe and press the like button, and I'll see you next time.